All right.
Are we gonna have this?
Possibly.
Okay.
We can discuss that after the meeting, but anyway. All right. This is a meeting of the Athens Board of Zoning Appeals, and the meeting is called to order at this time. The time is 7 p.m. The date is July 13, 2006. The board consists of 5 members and 1 alternate. The alternate takes full part in the discussions of the board and becomes a full voting member in the absence or conflict of interest of a regular member. Present this evening are members Betty Hollow, Roger Gruser, Greg Lavelle, and our alternate David Shafi, who will be taking full part this evening because John Golsey is unable to be here, and my name is Muriel Frederick. I'm the chair. Also present this evening are zoning administrator Steve Pearson, Paul Eschenbacher, our acting secretary, Mike Miller, our assistant prosecutor, and other concerned citizens. All right. The board operates according to the following procedure. The chair will name and describe the case. The zoning administrator will cite the specifics of the refusal. The appellant or a representative of the appellant then will state the case for granting the appeal. Testimony next will be taken from those who support granting the appeal, then those who wish to speak in general comment, and then those who support denial of the appeal. Following all testimonies, the board will receive concluding remarks from the appellant. Discussion from the floor then will be closed. The board will deliberate and render a decision. Under Athens City Code, Section 230703B, the board has the power to grant such variances from the code as will not be contrary to the public interest, so that the spirit of the code shall be observed, public safety and welfare secured, and substantial justice done. Athens City Code 230910C requires that variances from the code shall not be granted unless the board makes specific findings of fact based directly on the evidence provided to it, that each and every one of the following 6 criteria are met. The first is practical difficulty or undue hardship. There must exist a practical difficulty or undue hardship caused by exceptional circumstances pertaining to the specific piece of property. Number 2 is exceptional circumstances. There must exist exceptional circumstances or conditions applying to the property or its intended use that do not in general apply to properties in the same zoning district. The third, preservation of equal property rights. It must be determined that literal interpretation of the code would deprive the appellant of rights commonly enjoyed by others in the same vicinity, while granting the variance would not convey a special privilege. The fourth, minimum variance. It must be determined that the variance is the minimum required to make reasonable use of the property. The fifth is as absence of detriment. It must be determined that the granting of the variance will not be of a substantial detriment to adjacent properties, nor materially impair the purposes of the code or the public interest. And the last one, not of a general nature. The variance sought must not be of a general or recurring nature, such that the situation would be more reasonably handled by changing the law. The board is empowered to hear and decide applications for conditional use, and none of this applies here because this evening it's all variances we're looking at. All right. Any person who is aggrieved by the decision of the board may file an appeal to the Court of Common Pleas. Such petition must be filed within 30 days after the mailing of the board's resolution to the appellant. This evening there are 4 cases on the agenda. Number 0616V for 12 Strathmore Boulevard, which is zoned R2. James Carageorge is the appellant. Number 0617V for 121 Morris Avenue, zoned R1. Kimberly Mather is the appellant. Number 0618V for 9 North College Street, which is zoned R3. First Presbyterian Church is the appellant. And number 0619V for 919 East State Street, zoned M, the Kroger Company is the appellant. The board is required by law to take testimony under oath. Anyone wishing to speak this evening, or even if you think you may speak, please stand to be sworn. Do you swear that the testimony you will give to be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. All right. Our first case this evening, then, is 12 Strathmore Boulevard. It's 0616V. James Karageorge is the appellant, and Steve, could you tell us the specifics of your refusal, please?
My name's Steve Pearson. I'm the zoning administrator for the city of Athens, Ohio. The first case tonight involves Mr. James Karageorge, who owns and lives at 12 Strathmore Boulevard. We spoke several weeks ago about some improvements at his residence that he wanted to accomplish. And I think 3 pages in the packet of information that you have, I took the large sheet of plans and shrunk them down. The hashed out area is the footprint of the existing structure, and then there's areas that are indicated that will be additions, mainly on the lower part or the left side setback of the house, which is this portion right here that will include this additional lot coverage and some additional area to be enclosed in the front porch area, which is right out here. Mr. Karageorge owns 2 lots. The house straddles the 2 lots. But even with that larger area, there's a 2.4% variance required for maximum lot coverage. The lot coverage will be 32.4%. That's what is requested. And the maximum permitted is 30%. The left side setback, the request is 3.9 feet, and 8 feet is the permitted minimum. You have to stay at least 8 feet away. And the rear yard setback is just a little over 25 feet, and 30 feet is the permitted closest encroachment in the rear yard. So those are the 3 variances that are necessary.
The rear yard setback is the existing house footprint, is that right?
No.
Or that's part of the addition.
Right, it's part of the addition. A new one-story covered terrace is what's indicated. So
Gotcha.
there's a roof over top of a terrace area in the back. The existing rear yard setback is 38 feet. There'll be no additional encroachment in the front, although the front complies. It's 30 feet back. No additional construction or encroachment into the right side setback, which will remain at a little over 21 feet. In addition, in the packet of information that you received, there were 1, 2, 3, 5, 6, 7, 8 letters of support from citizens and residents in the neighborhood. And besides that, unless you have any other questions,
I'm just
really all I have.
clarifying, the footprint of the house as it exists was 36 feet something from the back. It had a 36-foot setback. And then there's to be an addition, but the addition is a covered terrace. Where, is that what I'm seeing?
Right, that's what's indicated on the plans.
Okay, all right.
Right, a one-story covered, new one-story covered terrace.
So it's a terrace that is encroaching into the setback, okay.
Right.
Gotcha.
It must be about 11 feet deep. Subtracting 25 from 36, it's probably 11 feet wide. It's 42 feet
Okay.
across its
So
width.
just 11 feet. Okay, thank you. All right, we'd like to hear.
Mrs. Frederick, other members of the Board of Zoning Appeals, thank you for the opportunity to appear tonight. I'm Chris Garrick here speaking on behalf of Jim Karageorge. The reason I stood up and raised my hand to give testimony tonight also is as a fellow member of the community that lives in the area just up the street from Mr. Karageorge's project, I would like to add my voice in support of the project as well. You've had a chance to see from our narrative statement the basic gist of the plans that we're bringing to you, and why we would request this, we would submit fairly nominal variance here tonight. We believe that this is a great addition to the neighborhood. You will see from the letters of support that have been written that adjoining owners, other people that are close in the area, and basically anyone in the neighborhood that would discuss these plans with Jim have all indicated their support for this project. I am unaware as of this time of anyone who would be against allowing Mr. Karageorge to go forward with this project. The reason this is an unusual request for this neighborhood is this house, as it stands now, was actually built on 2 lots. Well, when they built the house back in 1959, no one anticipated, if you were ever going to make improvements on the dwelling, that we would have a code, and you would have to administer that if you were going to make changes to the house. Well, times have changed, and the time has come now to make improvements to the house. But you have a very nice brick structure in place on these 2 lots right now that does not lend itself to being moved over so that it's properly centered, as might be required under the code in its present form. For that reason, we would ask the board here tonight to favorably address our request and allow Mr. Karageorge to go forward with what I think will be a very, very nice building that he's completed with.
When Steve told us that the lot coverage would become, was he referring to lot coverage of both lots? The total lot coverage actually is going to exceed the maximum that would have been permitted had there been 2 separate structures on 2 separate lots?
That's a combination of the total area of the 2 lots.
So, combination of the total area of the 2 lots becoming a new lot, and,
Just one
okay,
lot.
all right.
I would note for the board, though, that we're only talking about 2.4%
Yeah, but I
in
just
this
wanted to
case.
get clear for the record.
Yes, that is for both of the lots, though.
All right. Does anyone have any questions for Mr. Gehrig at this time? No questions at all? Nobody? Okay, thank you very much.
Thank you.
All right, well, this would be the time for someone who wanted to speak in support of the variance, or anyone who wanted to speak in general comment.
My name is Joseph Richard Sligo, and I live at 102 North Lancaster Street, and I'm a concerned citizen. I need to say up front that Mr. Karageorge is a close personal friend of mine. He happens to be related to the Sligo family by being related to my daughter's husband. Now, with that said, and out of the way, I want you to know that he knows I speak my mind and he speaks his mind, and sometimes we agree and sometimes we don't agree. Here's what I want to say about this. One, I see no problem with the back going from 30 to 25, okay? That's one thing. There's no problem, as far as I'm concerned, with the difference in the percentage of coverage. This is the sort of thing that's very close, and I think the board ought to grant the variance for that. I have only one problem with it, the whole thing. I went out there, although I've been there a number of times, I went out this evening to refresh my memory. And what I did is I went to the Conrath-owned property on the left, and I took my cane. I couldn't see where the 3.9 feet was going to be. This is a little bit over 2 feet. And so if he's going to have 3.9 feet, is it from the present fence or is it from that garage wall? The reason I ask that is because he's required to have 8 feet. Now, I don't think there's any way he ought to try to meet 8 feet. And he has a lot of coverage. He has a side setback on the right that's quite a bit. I even measured that, and I got 20 feet by pasting. The one I have question with is how close will this new addition be to a garage, existing garage? In other words, Mr. Karageorge and I have discussed this in terms of my experience here and other places. In some places, each one has to have 5 feet off of the property line to give 10 in some places. Some has 16. You understand what? It varies. And all I'm after is the fence coming down? I need to know that. And if the fence is coming down, then the end of the addition will not be up against the garage this distance, but longer. Where's the 3.9 measured from? That's all I need to know. As soon as I know that, then I can make another statement. But if I don't know that, I can't, because the existing fence is extremely close to the existing garage. Now, I know what happens in small towns and large towns. Developers go as close as they can. They push the regulations. They've got, Mr. Garrett says, out of respect for the law profession, they have good lawyers, they have good advisors, and I understand that. But I would be concerned if this addition is right up against that garage. As you go past on the street, that would be, it would be quite different from the housing out there. You understand what I'm saying? Anything else?
Well, I'd like to know where the measurement is measured from. Did you get a chance to see the drawings?
Yes, I saw the drawing, but I can't tell. See, the plat maps are not official boundaries. And you have to have, and the reason I know that is over in the court, the gentleman that provides plat map has a sign up there. You need a surveyor. And all I'm after is, I don't know where the property line is. I assume it's halfway between the fence and the garage. As a matter of fact, we ran into a case one time here in Athens where a house on Court Street is over on the other property, and they can't do anything about it. It was done years and years ago, and they've been there 20-some years, but it's been about 50 years, 40 years. And all I'm after is, I don't want to see the addition be spoiled by being too close. And with that, I'm in favor of everything, and that's the only thing I would say is, I was concerned about how high it's going to be. Now I know it's going to be one story. There's no problem. Anything else?
Well, I'm sure we
I
can
appreciate the
find out.
board's patience.
Thank you very much. Would you like to address that, or Steve, would you be able to, who would be able to address it?
I want to speak to the matter of law, and then I'll provide it.
Okay.
If you look at there is a tax plat attached to the drawing, but it's just to indicate the zone areas. The drawing that you have is not actually a survey, but if you look at it, it calls out directional information and distance information that's normally contained in a deed, in the property description in a deed. So, for example, out front it says, on Strathmore Boulevard, 109.83 feet. Excuse me, on the north, 104.72 feet. Same dimension on the back, 109.83. So generally, when you see that, that's call-outs off of a deed or off of a survey.
Okay.
So this is not an actual survey. It's not been sealed by a registered surveyor, but I would believe it to be an indication of the actual size of the
site.
property. Now, the distance then of 3.9 feet is measured off the property line, but there's no indication about the location of buildings on adjacent property or the location of fences or anything like that. So that information I don't have.
So,
The only thing I can tell from this is it's 3.9 feet from the property line.
Is there anyone that does?
Before you
I don't.
answer Mr. Bruiser's question, since you seem to need to step away to answer it, what are the actual dimensions of this addition? It appears to be at least 3/4 as big as the existing house by our little sketch.
The addition, if you look in the drawing,
Right.
on 49 feet from the
Okay,
street
wait-
toward the rear
wait,
property
I'm sorry,
line.
I have to find the 49 feet.
Across
Okay,
the
good.
back,
Okay, and
it's
then,
42 feet.
okay, 49 this way and 42.
42 this way.
Okay, sorry. Okay,
Yeah.
thank you.
Right. Now, part of that is already covered with an existing portion of the building. So that portion is indicated on the drawing, says existing structure to be demolished.
Right.
And then this larger 49 by 42 footprint constructed.
if you look at it that way, it's not 3/4 of the, because there's building already there.
Well, that building's going to be gone.
Yeah, right.
So it's still going to be 42 by 49, and I guess I'm wondering why it can't be 37 by 49.
Yeah. Right.
That's still quite handy addition.
Good question.
Okay, well, this is the question that we'll need to ask. Thank you, and
I think I can bring a lot of assurances to you on at least some of the questions that you've raised, Mr. Sligo. The first is in regard to how you look at the platted lots in a subdivision themselves. You don't have meets and bounds when you plat a subdivision because those are all referenced on the map itself, and that map does give dimensions. And there have been pin set for each one of the corners of those lots. So it's easy to perform a survey on a city lot and determine exactly where that line runs. There has been a survey done on these lots in anticipation of this project, and the builder has reflected that information in his information he's given to you here tonight. So we feel very confident in the numbers that have been presented to the board that they are accurate. With regard to the 3.9 feet, we're talking about a distance that is less than about 2/3 of my body length. So we would submit that this is not a particularly dramatic change. We would also submit that the neighbor immediately adjoining this lot, Mr. Conrad, has written the board a letter in support of this project, saying that he feels that this will actually improve the value of his property if this improvement is made to his property. So we would hope that the board would look favorably upon what is in essence a fairly modest request. I'm very hesitant to start changing the plans of the builder as far as the amount of footage that it goes over in one direction or another. There were reasons that he drew this out. Some of them may have been, I'm not sure what the reasons were. Some of them may have been structural, some of them may have been aesthetic design as far as
He wasn't
balancing it out.
available, so we could discuss that with him.
We were hopeful, I guess, that the plans would speak for themselves here tonight,
Well,
as far as that goes.
I
but-
agree that each one of these requested variances is relatively minimal. However, there are several of them, which then collectively makes it a little bit less minimal.
Mhm.
And as you say, if he wanted to meet that setback on the side, you're only talking about half the length of your body. So that's not such a dramatic change.
I guess the only request we would continue to submit to the board, though, is that this is yes, there are 3 requests, but they are fairly de minimis, many of them in nature, and we would hope that the totality of them would not cause the board to look disfavorably upon our request. I would bring the board's attention back to the people that live in the neighborhood here, have spoken with some unanimity that they think that this is a good project.
I think Betty's curious, and so am I, regarding this particular setback. All the others appear to be within a reasonable amount, but if we knew exactly what the nature of this addition is and how important it was that it extend that close to the property, then we would be in a better position to make a judgment.
I take it that this is to be a 2-story structure, right?
It is a 2-story structure.
Called a
much like
bedroom
the-
annex.
I'm sorry?
I think it was labeled a bedroom annex at some
Mhm.
point, and so,
It's a garage.
I see. Okay,
And several rooms.
okay. And the driveway is going to come right here, okay, I see that, okay. So the garage is on the bottom and the bedrooms are
Because
up
of the
at the top.
existing structure to add on, the reason is why we're asking for variance, because we have to take part of the house off. In
Part of
addition
the
to
house,
part-
are you talking about the covered terrace? Is that what you would have to change?
For the side that we're talking about,
Mhm.
it would only entail taking the laundry room off and the existing garage. If we would come in further, we would have to actually go into the rest of the structure.
Oh, you're not
I'm not
planning to
following you.
demolish the entire section here that it's indicated on our drawing, existing structure to be demolished. That entire structure is not planned to be demolished.
No. No, just the garage and the laundry.
I see, okay, gotcha.
There's the garage and the
There must
laundry.
be, this must be the garage and the laundry
Which
room,
is
the little
the
rectangular.
little rectangular.
So what's to be left? I guess I'm just
It's
not
this-
understanding the drawing.
It must be this part that's gonna be,
Well, I need
I
to
don't know
know
what that
that.
is,
I
yeah.
mean, what's going to stay, what's going to go? It appears to me, in any case, and probably, well, you need to explain to me why it's important that you can't move this back 4 feet to meet the variance on that side. What's happening interiorly? Well, why don't you change places at some point?
I was going to say, well, I'll let Mr.
Yeah.
Carrigeorge speak to this.
I'm sorry, that is an existing laundry room, and to incorporate it.
Okay, tell me what, can you show me what is the existing laundry room?
This is the part you're gonna take out?
This is a laundry room right now
Okay.
with a one-car garage.
Okay, and you get into this garage how?
Well, right
Right
here.
now? Okay, all
And the
right.
problem is I can't fit a car in here.
Okay,
So this would incorporate a two-car garage
okay.
and allow a laundry room.
This
Larger.
same laundry room that's already here.
Right.
Okay, so then, okay, so basically,
So-
is this going to disappear?
This is all going to disappear.
All of it?
all that's
All of
disappearing.
it's gonna disappear?
Oh.
Okay, then I still don't see why you can't cut 4 feet off
So
of that.
then the reason that you're making this addition the size that you're making it is in order to be able to accommodate a two-car garage, is that it?
Well, you could still do that.
Well, but the
Still
kitchen
have-
is very small. It
you'd
takes
still
up
have
about
49
this
feet.
much, so you didn't.
Well, I know,
Yeah,
but you're
come
talking
out.
about 42 feet. That's twice the length of most rooms. You got 2 rooms worth of
Two-car
stuff there.
garages are typically 24 inches wide, or 24 foot wide, I'm sorry.
But it'd actually be 2.5
Well,
with
so you
the
got
laundry room on
49
it.
feet here.
And so the
Okay, so
laundry
you got
room
plenty
and
of
the
room.
garage. But the garage
This-
part is,
This is the part that I'm asking about. Why can't you change that from 42 to 37 or 38?
This is a terrace that comes out, just a
What-
covered porch.
Well, can you not whack that off or build, and maybe I'd even say, yeah, keep that, but I guess I just don't understand why that 4 feet is so vitally important that we need to give you a variance for it.
Well, the bedrooms are very small, and so
In this
that would
house.
incorporate a bedroom upstairs.
But it's 42 by 49, it would be 38 by 49.
I understand.
That's
If I was the
huge.
builder, I could
That's
actually talk to
huge.
that. If it
That's
was
really
investments,
big.
I could, you know.
Right,
But
that's
when it
really
comes
big.
to, because of all the changes that are going on in this side
Right.
of the house, he needed the additional space so that you could have a two-car garage and room here for storage. There's no basement here. There's no
Okay.
way for basement. If you go to the upper level of the house, there's slanted ceilings, so there's absolutely no room for storage.
Right.
So it'd accommodate, as you're saying, it's big for a garage, but it's
Right.
big so that you can store things there as well. Otherwise, there's no basement, there's really no closets upstairs to speak of, and the room is more of an attic.
Okay.
What size
you-
are the bedrooms upstairs? Do you know the
Yeah,
dimensions?
you need to go back to the mic so everybody can hear you, but thank you very much
Sure.
for showing me that.
I'm sorry, you're saying?
I was asking what size those bedrooms are upstairs. Do you know the dimensions?
The current bedrooms are the ones that we're looking at
The ones that are in the
Adding.
new plans?
in the new plans. It would incorporate a bedroom, a bathroom, a master bedroom, master bathroom. As the house is now, if you have a king-size bed, I'm a pretty large guy, okay, you can walk around the perimeter of the bed in the bedroom, and that's it. There's no room. So what it'll allow me to do is really have a 2.5-car garage, if you will, the half part to be used as storage, the 2-car garage to be used to basically store cars and so forth. And then that would incorporate a laundry room as well. As you were saying, the upstairs would be a master bedroom, a closet space for additional storage, a bathroom, and an office. I do a lot of work out of my home. And it'd be nice to actually have an office that I could put a desk in. Okay.
And so it also
So I'm not
incorporate
asking you to go down
the
this stairs. I'm just asking
existing
why it
structure
can't
to
be
stay
this,
as it
and he's saying
is.
This covered terrace is the problem.
Okay.
So what we're saying, does it have to be that big?
That's my
Well,
question.
And we need to have the builder here in order to.
Yeah. So perhaps we should continue the case.
It
Ask
looks
for the
like the
bill.
laundry room is like gonna be an
I
18.
think that'd be a good idea.
I can't tell that.
Let's ask for continuance. And have the
Have
Well,
it
a
builder be
normal
present.
garage, he says, is 24 by 20.
Yeah, this is huge.
It's ridiculous.
And it's huge for a bedroom space, even if you're gonna add an office and a
Yes,
big
they
bed. It's a
wouldn't
huge.
Well, he
So
went from
if
two
we
car
could
to
talk
two
to
and a
the
half
builder,
A
car.
little bit out of proportion with the house.
Well,
actually.
and I can see, if you're trying to build it out to here, because this already exists, but why can't you just move back from that and have a little
Yeah.
architectural interest?
I'm
Right.
with you, but I'd just like to know.
Well,
Let's make a motion for a continuance.
well,
If the board feels that it's important to hear from the builder in this regard, we would be happy to continue this
request a
proceeding to the
continuance,
next
that's what
meeting.
we're considering,
And-
suggesting.
And Mr. Brooks is regrettably out of town this evening.
Okay. It's always hard to wait another month or so when you're making plans to build, but I think that would be very useful to us to be able to hear from the builder the reason for having to have this, because, as Betty said, each individual variance by itself is not so great, but when you start piling them all together, it gets harder to find for minimal variance. So, yeah, if we could hear why, it would help.
We'd be happy to bring it. So please consider this our formal request then to.
Thank you.
Thank you.
Table this and
Does somebody want to move for this, or shall we just by fiat?
Well, are we saying that we agree to allow them to do this?
That's what we have to
I
decide.
move that we allow this case to be continued and rescheduled at Mr. Pearson's discretion.
Is there a second?
Second.
And all in favor?
Aye.
Aye. All right. Steve, it would be helpful if we could continue this, so he set it up. Thank you. Thank you very much. That does help. Okay. All right. Well, then this one will be decided when we get to hear the full testimony of people who can tell us the answers. Thanks. Okay, then our next case.
Just to continue.
We
yes.
voted to continue because we need to hear some details, information that wasn't available to us right now. We all voted in favor of it. All right, for our next case this evening, then, we have number 0617V at 121 Morris Avenue. Kimberly Mather is the appellant, and Steve is going to give us the specifics of the refusal.
Included in the packet of information that I gave you was a site drawing provided by the applicant. I also, hopefully in the packet, yes, is a copy of the tax plat of the area indicating that the property is located at the intersection of Morris Avenue and Campbell Street, so it's a corner lot. I also attached the packet of information that you have, section 230308 called Yard Regulations. Essentially what it indicates in section B is that corner lots have two fronts. Instead of calling it two fronts, they call it a side street setback. The indication is that it's the same setback required in subdivisions platted after 1960. It's the same as a front setback. So on a corner lot, you lose 25 feet off each street frontage for building purposes. Any subdivision platted before 1960, which this subdivision was, only requires on the side street setback a 12.5-foot setback, which is half of the 25. So you first have to look at that regulation. It essentially says a corner lot has two fronts. The next section talks about which is 230314. It just says, it's got some regulations on fences, but then it says, however, no fence or wall, regardless of height, shall extend beyond the building front setback line in accordance with the standards and regulations. So in this case, that side yard setback, or side street setback, excuse me, on Campbell is 12.5 feet. It's a pre-1960 subdivision. The request then is to have a fence that
So you can
is right on that setback, or 12.5 feet back from the property line.
give him a maintenance area.
And
I think so too.
that's indicated, the property line, or the Campbell Street right-of-way line is indicated right here. This fence extends out approximately 5 feet from the existing house, an existing garage. So really the only, looking at these two smaller areas, right here and right here, that are encroaching.
You mean on either side of the garage, essentially?
Yeah.
Right. If the fence were to be pulled back and line up with the house, then it's not an additional encroachment. You could have the fence there. However, it does really then make for a very small yard to be fenced in. Like I say, it's about 5 feet off the house, which means from the fence to the actual curb line of the street is going to be about 7 feet. So from the curb back, 7 feet of grass, which there's an older sidewalk there. It's kind of hard to see, but there is an area where pedestrians can walk. There won't be any problem with the fence obstructing pedestrian traffic, and the fence will be right there on the property line.
The rationale for putting the fence back is to keep from restricting view?
Yeah, what is the reason that the...
Fences aren't permitted in
the
front yards?
fences, what was the reason that that a corner property, is there any safety issue involved in a property like this having a fence as other property owners would be permitted to have in their side? Any safety issues with having this second front yard being a side yard?
I guess the first question is, or kind of to answer it, everybody's allowed to have a fence up to 6 feet high right on their property line. So if this were anywhere but on a corner, they could have a fence there.
But again, the rationale must be that if you have it on a corner lot, that it's obstructing somebody's view, a driver coming down that street. Is that the reason for it?
The prohibition on fences in front yards is for all lots, not just corner lots. But if the question is this going to obstruct vision across the corner?
Well, it's a 4-foot fence, so...
Yeah, the answer is no.
Right.
Because you'll still be able to see across a huge triangle.
Do you know what the reason was that it was determined that for corner lots, the side would be considered a front?
I have no idea.
The street side would be considered a front. You don't know if it's just something
Well-
irrational? Somebody just decided they like the looks of it? Or is there some rational argument?
When the code was drafted in
that would support
1960, I have no idea what the rationale was.
Maybe I
or
could
what the
help with
model-
that.
But I do have an answer.
If I'm in a subdivision and I'm building homes, I'll want to have a nice line along the street, and that'll include the corner. And then if I turn the corner and go the other way, I'll want the same thing. So I need to have that corner house line up with the existing homes on either
Okay,
street.
so the
And
argument
that's
is
why
that-
the setback would be,
So the argument is an aesthetic one from the point of view of a builder in a subdivision, not having anything to do with the town.
right.
Okay.
Well, it just looks nice to see them all lined up. You wouldn't want the corner one to
God,
be
you're really
out here 10
attentive.
foot further than the other homes.
Yeah, the corner one, you could choose to have your front door on either, your
Right.
front entrance.
Yeah, you
on
have
two
the
different
option.
Options, whereas all the other houses on that street
Uh-huh.
are the same.
Okay.
So
But
you've
this
got-
is a subdivision argument, however. We are still speaking about a subdivision, not about anything that has to do with health or welfare or safety
No, it'd
issues
be
or
a
anything
fair-
Well,
like
the
that.
safety issue was
Okay.
about a corner lot, if you had a 6-foot fence and it obstructed the intersection, that is a safety issue,
Yes.
and it is one of the,
Right.
in the code
Yeah.
about that.
But, okay, but Steve has indicated that this, in this case, would not be the
No.
case. Okay.
Right.
Mike?
What I was trying to point out by showing you both those sections of the code is they really don't seem to have any relationship, but they do affect each other. And I think, as Roger said, the reason I think the code says 25 feet after 1960, that's when the code was adopted. So you don't want that corner house sticking out. On each corner, you want it to line up. Problem is then on a corner lot, you've lost quite a bit of yard just to meet the regulations compared to interior lots. You've also lost the ability to completely fence your rear yard or any portion of your yard not forward from the front of the house toward the street. So corner lots are at a great disadvantage, really.
I live on a
You
corner
lose
lot.
building area and you lose fenceable area. This is in the rear, it's not in the front. The rationale, I think, for fences in the front, and I don't know if I just made this up or if it seems reasonable, but, you know, a lot of people imagine that they're going to have their dream house with their little white picket fence in the front yard. Well, for safety services, when we're responding to problems at a house, the last thing you want to have is any kind of obstruction trying to get to the front of that house. You don't want cars parked in front of the house. There's no prohibition for trees, but you want to be able, as easily as possible, to get up to the front of the house. And I've always used that as a rationale why fences are not permitted in the front. Any additional obstruction would limit the ability of service and safety officials and employees to do what it is they need to do.
Okay. Reasonable sounding. Makes sense to me, too.
So we might, if they might jump a 3-foot fence,
Okay.
4 is getting a little high, but in any case, the law just says no fences in the front, regardless of height.
Okay. Interesting. All right. We're ready then to hear from the appellant who wants to build a fence. Who is the appellant? They're not here. Okay, well,
Shall we skip it?
does, when an appellant just doesn't show up, do they get to come back later, or? Steve, tell me what to do next. I've not had anybody just no-show for a hearing before.
If you,
Actually, we have, we skipped them, yeah.
if you look in
But we
the
knew it in
record
advance.
file,
Yeah.
there's a copy of the notice to appear.
Must be this one. This is Jim. That must be this one, isn't it?
We know the person who comes to the podium is not here.
Just
See, I
changing
didn't
minds.
know the people, so I didn't know they
Obviously,
were here.
Definitely changed their mind. They've got 2 young children wanting to build that fence.
Maybe they sold your house.
They just bought the house.
Included in the file is a copy of a letter that I sent to the appellant. It says your appeal under zoning ordinance relative to 121 Morris. And it has the case assignment number, it has the date of the letter, which was 2 weeks ago.
Okay.
It sets the date in bold letters. Then it has a note. If fewer than 5 members are available for the meeting, you have the right to continue until such time as 5 members are available.
Does it
Is
make
the
clear
usual-
that they're supposed to be here?
It says notice of hearing and appeal.
Yeah, but maybe they didn't know they were supposed to come.
The notice says you are notified to appear before the
Okay.
Board of Zoning Appeals, either in person or by
Okay,
agent.
as long as it says.
I don't know
right
what else
there.
I can do.
Okay, then you know what?
I don't know what else I can do.
I can't imagine why they're not here, but I guess we're going to skip them.
Can I make a comment?
Surely,
Briefly.
briefly, so that we can move on to our next case, but,
I was amazed to learn they were not here, but I can explain, I think, one theory why they're here. This is a very strange day for the Board of Zoning Appeals to meet.
well, it is a
And
strange
they might have thought it
day.
was always on a Tuesday. And did they ever get the date, the 13th? Did you tell them the date?
Yeah, that's what that letter he just wrote.
Does the letter say the 13th, Steve?
Yes, it does.
Okay, I only thought maybe they forgot because
Something happened and they didn't make it, so we're going to have to go on to the next case. That seems
You-
pretty clear. And, all right, I'm gonna put this back in the file before we start the next one, but. Yeah, okay, then,
It'd be
moving
unusual.
right along.
Madam Chair,
0 for 2.
Yes.
just continue it.
They haven't requested a continuance. If we were really nice, would anybody like to make a motion that it be continued? No motions
Well-
for continuance?
Don't you suppose they'll be back to Mr. Pearson and say they want?
I mean, if they've got an emergency or anything, they certainly have a telephone. If you aren't going
Well, I'm
to
not
take
gonna
us
be so
seriously.
They'll have
mean
to
that They
reapply.
can never come back.
I
I'll
move
move that we grant continuance.
Thank you, I second that.
All right, who would like to continue this case until we hear from the appellants?
I will.
Aye.
Okay, all in favor?
Aye.
All right, yes, I also would like to do that. Our next case is the third case, moving right along. It's the 9 North College Street for the First Presbyterian Church. It's number 0618V, Zone R3. They are present, right? Yes. Good. All right, Steve, would you like to cite the specifics of refusal in this case? Good.
Again, included in the packet of information I provided to the board, you have a copy of the refusal, which states the basis of the refusal and cites the code sections and cites the deficiencies. Second page in the packet, usually that I give you, is a tax plat with drawn onto it the zoning boundaries for the adjacent zones. This property in particular is 9 North College Street. It's just around the corner from right here. Right over here. Actually kind of in front of and off to the side of the police department, front entrance. The third page, you have a footprint drawing of the building. Now, the renovations that have taken place in the building did not include any additional exterior expansion. It was all internal work. As far as I know, the entire building had been dedicated to uses related to administrative nature for the Presbyterian Church. The plans, I think, have indicated that it's their offices. The proposal was to add an apartment upstairs. And the zoning code says when you change the use of a structure, any portion thereof, you have to comply with all the parking regulations. So the parking regulations in this zone, which is R3, does not permit stacking of cars. It requires, let's see, it would require 3 parking spaces for the office and 2 for the residential use, assuming single occupancy in the 2 bedrooms that are upstairs. So there's no exterior expansion. They've just converted the second floor of the building to an apartment, supposedly for two persons. That would require 2 parking spaces, 3 for the office, total of 5, all have to be accessible. The church does own the parking lot next to the police station. They lease that to the city, so they actually own the parking lot right next door. And it's my understanding that their preference would be to, rather than deed restrict those parking spots, would be to show a lease each year to the code office and have that contained in the rental permit file. An additional variance, I believe, though, would also be necessary because stacking is not permitted in an R3 zone. We've had lots of discussions about the stacking of cars. But anyway, indicated on the back of the drawing, there's 2 parking spaces back there. They're deficient in width, but in reality, you can park 2 cars behind the building. And then from there on out, any car that you'd park in the driveway would trap both those cars.
So they don't currently have sufficient parking even for their office?
They're grandfathered for stacked parking.
Yeah, but they've lost that by doing the
The
change.
code says that any change of use in the building or any portion thereof, requires parking to be compliant with all parking regulations. So
Okay.
no stacking,
This is a parking place. This is
and
Yeah.
meet the requirements for parking.
But they have this up here as parking, but once
You
these
could
two
probably
park here,
physically
that's-
put 2, 4, 5, 6, 7 cars in there, in the driveway, which is 2 more than what's required. The problem, though, is stacking's not allowed, accessibility is required. And because none of these spaces can actually be counted over 1, then those additional parking spots for the residents have been proposed to be in leased spaces less than 250 feet away, actually right next door, and in the same ownership. So a lease in lieu of a deed restriction.
And what's the problem with deed restricting, so that they're complying fully with the code?
They're not deed restricted.
But they
No, they're
haven't
not.
been,
They're
but they
asking
could
for
be, and then
minor-
they'd be in compliance.
Right. Well, they still need a variance for stacking for the business use.
Yes, okay, but that would be that would be minimal, there are only going to be 1 stack.
Right.
Or they could provide parking for the business also in their own lot.
Right. The only thing that I always point out to appellants is, if you deed restrict parking in your ownership and within 250 feet, there'll be no need to go to the board.
Right.
So they've opted to request, as far as my understanding is, to provide a lease in lieu of a deed restriction.
Well, even though these 2 lots up here are too small, do you find those acceptable? The 2 existing spots, are they accessible?
I would say they're accessible if none of these other cars were parked here.
Well, just these 2 on the left, are they
Mhm.
accessible?
If there
If
aren't
none of these cars are parked
obstructing
in the
driveway.
This is
So
just a
you're saying you
driveway
have to
here.
come up the driveway
Yeah.
and then get over there?
Right,
Oh,
there's
okay.
an 11-foot, right here, it's indicated 11 feet, 3 7/8 inches.
Right.
It's a width
okay.
from the side of the building
So they'd really be
to the
trapped.
property line,
Yeah.
which is
This
just
is
a
the
little
driveway.
past the paved surface of the
You never
driveway.
get out.
Oh, okay.
I mean, so this
It's a
is
single
really
car
there's
wide
It's a
driveway.
two-lot parking lot.
Well, it
with a
looks
long
like it would
driveway.
just be simpler to let the tenants have those 2, and then the employers could get something on the next door lot.
Yeah.
Wouldn't it be easier to keep up with the Presbyterian minister and his assistant than some people who are less
Yeah, I'm not
prominent?
sure, I'll let representatives of the Presbyterian Church justify their understanding, interpretation, motivation. I wouldn't want to be known to speak for the Presbyterians.
Okay. All right, well then, thank you,
Amen.
Steve, for your presentation, and we're ready to hear from the appellants.
I'm Scott Malcolm. I reside at 31 Utah Place. I'm financial secretary and a member of the First Presbyterian Church. And first, I should say, actually, there are 3 parking spots back that are accessible and used every day, except right now, in the renovation, we're not using them because the construction people are back
Oh,
there.
so where's
But
the third one?
The 2 that Steve pointed out are very accessible.
Okay.
Then right behind them, if you turn that 90 degrees, and so that the automobile is facing outward,
I
it's
see.
quite easily to take either one of the 2 automobiles that are back there and back around them and get out.
I see, okay.
I've
So
done it
there are
many
actually
times.
3 parking
There are actually
places
3
now
acceptable spots.
that are
Yes,
being
right now.
used, okay.
They do not meet the width of the code, but they're actually used every day.
Okay. Thank you. Okay.
Do you want a history of the property and why we're changing?
We assume that it's because the church needs more money.
That's part of it. The upstairs, the downstairs portion has been used as the office. The upstairs portion presently has just been falling into disrepair. And it seems silly to have this place upstairs empty and falling down around us. And it was considered to change it in renting out to business, but there's no businesses interested in renting property downtown. And there's a high demand for property being rented for residential purposes. And so it would add income to the church. And it would also upgrade the property, which is falling down around us upstairs. Otherwise,
So
there's
you're
no-
planning to put an apartment over the top, is that the idea?
They have.
there's a second floor at the house, is a 2-story house.
Yeah,
And the
but
downstairs is used for church offices.
my
The upstairs is.
Sister-in-law
vacant.
worked there several years.
Previous to the time when the church bought the property in 1961, the downstairs was used as a funeral home and the residents, the people live upstairs. So we're essentially turning it back to that was when we bought it, making professional offices downstairs, or residents upstairs. The property's further complicated in a little sense because about 25 years ago, the city came to the church and said, "We want your property," because they wanted to build a law enforcement building. So the church agreed to sell the city part of the property, much to the consternation of a number of people in the congregation, because they sold the back of the property and they sold the strip between the property and the parking lots, which means they separated the house from the adjacent parking lots, which means you no longer have this nice large piece of property. But they're only putting in there a walkway. So there's a walkway that separates 9 North College from the property, the parking lots next door. So,
And what's your reasoning for leasing restrictions of the parking spaces and not deed restricted?
well, what we're really asking is we're not interested in actually leasing either. That was an option. What we really would like is a variance from the zoning code for the 3 things noted in the denial to permit the property at 9 North College to be used as a church office and 2-bedroom apartment with 5 spaces, not all of which are accessible.
Say the last part.
All right.
All of which are accessible.
They said we need 5 spots.
Okay, so you want
And
stacked
it said that
parking.
actually if you stack them, we could have 7. So we think the minimal variance needed is to grant us to be able to use the property with 5 spaces, not all of which are accessible. Okay? Yeah. The only thing we need is a variance for accessibility. Even if we were granted the variance, we would not use the property in that manner, because we already own the lots next door with 51 places. So that the tenants upstairs, if they have cars, will be allowed to park on the property itself without any interference.
Well, okay, wait a minute. They won't park next door, they'll park on the property itself.
The tenants will. Mhm.
Yes, but they
Yes.
won't be able to get their cars out.
Oh,
in
no,
the
they
daytime.
will. We only want the variance to allow us to go forward. We're not going to use it that way. We are not going to stack cars in there, but that's the variance we need.
So what happens
I'm
when the
sorry, I
property
don't
is sold to
understand why you
somebody
need it.
else and it's got a variance for all these,
All right,
all this
okay.
parking?
We
I
were
don't get-
very strongly told, do not encumber any other property that you own. Let the property at 9 North College stand on its own merits, because there is sufficient parking on the property. If it were used as a business, it's within 250 feet of the parking garage, you only have to be 500 feet. If it were used as a residence, you could stack all the cars in there you wanted to, and you wouldn't need a variance.
But not
The-
in an R3 district, which it is.
Yes, correct. And that's because it's an unusual property. It is in an R3 district surrounded by a parking lot, a police station, and a fraternity.
Yes, and sorority houses and
Right, across the street.
a number of other residential
Mhm.
properties,
Right.
some
But
of
we
which
feel-
abide by the parking regulations and some of which probably don't.
Right. But we feel, though, that we considered, putting a deed restriction on the property, but our attorney said, that's the last thing you want to do. Go all the other options before you restrict anything with a deed restriction. It makes no sense, he said. So we're following his advice.
But it does to the zoning
It will
code.
meet the zoning code, but we were advised to come to the board for variance rather than to go that route.
Okay.
Because
See you again.
we do have parking.
Right?
He said, do not make this the last thing you want to do is to restrict the deed. Oh, see, it's
Well-
not on that property, it's the property of the.
Right. So that you are supposing that ever after, all Presbyterians will have high regard for this plan that you're making now,
Mhm.
and that they will, in future generations, continue to honor this plan.
Oh, I think so, because no one likes stacked parking. If you are going in and out of the church office, you do not want to wait for somebody.
However, you would have the variance for stacked parking.
You'd have permission
And
whether you did or not.
Inevitably, the cars would stack up higher.
Yes, they would.
Well, then, in that case, we'd say we'd like a variance that would grant us to use the property with 3 spots which are accessible. forget the stack parking.
Okay, and then if we said that would be fine, that
Mhm.
you could have the 3 spaces, which seem possible,
Mhm.
then what are you going to do about the other 2? You'd have to deed restrict them, or,
Well, we presently, when we lease this lot to the city, we reserve right now 5 spaces for use by the church. That's been done for the last 10 years.
right.
So that we will continue to reserve those spots. There's no doubt that we're not about to allow stack parking go on, and the ministers don't want it.
They
don't
just
want it.
wouldn't be deed restricted, is
That's
that what
right.
you're
That's
saying?
all we're asking. We do not want to deed restrict the property.
If that were your only option to deed restrict 2 of those 5 spaces, would you accept that?
No, we don't want to. That's the reason we're here. We'd not have to come to the zoning board at all if we deed restricted.
Everybody who comes to the zoning board has something they do not want to
No
do.
variance is needed.
That's right. We do not want to do that. We are therefore must come to the zoning board.
Right.
And we
Okay.
feel that our argument should be compelling enough because of all the parking that is available that we have. We have a parking garage, we have the spaces behind that building, and we have the parking lot next door, which has 51 spots. I mean, they'll tell the city police they can't park there anymore and we'll restrict all of them.
You're saying you want us to give you a variance when you don't need it.
Well, they do need
They
it.
do need it if we do not want to encumber the adjacent property. And we were strongly
Okay.
advised
So,
not
so
to
what
encumber
kind of
adjacent property.
arrangement are you going to make
what I
with the
mean.
code office so that they have some control over whether or not you have in fact provided 2 spaces for either employees
Mhm.
or the tenants?
Right, this was the second alternative mentioned by Mr. Pearson, and that was to each year take a copy of the lease over to the code office that verifies that we have spots reserved for these people on the lot adjacent.
I see.
We thought that would be a hassle.
But you would still need a variance for the third non-conforming parking space in, so you'd need a variance for a third non-conforming parking space?
They're all
No.
non-conforming,
Well,
aren't they?
yeah, for 3 non-conforming parking spaces, and then
Who needs it there?
be able to show that annually that you're providing the additional 2
Well,
parking
they're
spaces
too-
by lease.
Too small? Yeah, you need a variance for all of it.
Okay.
And of course, the thing it is, the possible tenants we have right now don't have cars, but
Well,
that's beyond the point.
We
I think
can't.
that's,
Okay.
the other thing was that essentially a variance would not go with the properties because if you grant the variance for use by a church office and 2 apartments, 2 bedroom apartment
That
upstairs.
sounds even more difficult to control than a yearly lease that somebody looked at.
That yearly lease sounds good to me.
That's a possibility. We will not fight the yearly lease. We think it's a
But
little
you do
hassle for
want
both
something
parties
from us,
involved,
don't
but
you?
we,
You do want something.
Mhm.
Okay.
That's why we're here.
Uh-huh. Okay.
Okay.
Okay, well then, upstairs is going to become a dwelling again, and downstairs is going to be nicely refurbished office space, and you're requesting 3 parking places as they exist to be by variance, and 2 parking spaces to be provided for the tenants upstairs by lease.
Look, actually, if we have tenants with cars, they will probably park on the property itself. Well,
But
Well,
what she's
well,
remarking about is
either
the
one.
wording that
Yes.
we would be addressing.
Right.
Your
mhm.
Okay. Okay, thank you. Is there anyone else speaking in favor of the variance? Or in general comment?
Joseph Richard Sligo, 102 North Lancaster. I had a problem with what I heard Mr. Malcolm say, and I had a problem of why you need a variance for stacked parking and not use it. They actually need 5 places altogether, right? 2 for the apartment, and they want 3 for the workers. That's 5. Now, they have reserved in that parking lot, which they own, because I go in there and it says reserve, reserve, and you can't park there. Now, the only problem I see, now, Mr. Malcolm mentioned to me about the deed restriction when he came over and said hello to me. That's good advice ordinarily. Attorneys tell you that all the time because the more you put on it when you go to sell it. Here's what I'm after. I think the board could say that as long as that apartment is there, 2 places have to be on that parking lot that the Presbyterian Church owns, and if they sell that, then out comes the apartment variance. And then Mr. Malcolm made another remark. He said they don't want the variance to go with the property. I thought the variance always went with the property.
It does.
It
I may be
does.
wrong.
It does.
In other words, if he's got 5 places there, he doesn't want stacked parking. He can see why that wouldn't work. And if you have visitors from out of town, you can always use one of those 5 places for them, can't you? See,
No,
and
because
as
it's
long
stacked
as the
parking.
Presbyterian Church uses that lot and keeps it and doesn't change it and sell it for an apartment house, you're all right. But to see the minute they sell that lot and there's no guarantee that the students can park there as part of their deed, you understand why this is almost like the Byzantine Empire?
Well, except, of course, that, well, never mind.
Yeah,
One could argue you don't need the apartment, but that's not what we're arguing. If they didn't have the apartment house, there wouldn't be any
They wouldn't have
problem.
a problem, sure.
That's right. Is there anything else, board, I want to ask? I had a hard time with this one
okay.
because of the spacing and all that, and they do have construction back there and you can't see. But I do know they reserve those 5 places, and quite often during the week, they're empty and everything else is filled. And I felt like going in there and see what happened, get a ticket, I suppose. They tow you, I think, don't they? I think there's a tow sign there. Thank you very much. Bye.
Thank you,
I'm in favor of
thank you.
the idea of the apartment.
Is there
As long as you
anyone,
guarantee the parking.
is there anyone else who wants to speak in general comment or in favor? And if not, is there anyone who'd like to speak in opposition? There's no one.
Check with Steve and see if we can grant a variance that would be renewable each year.
Yeah, I think we should.
Yeah, we
have
probably
Steve
should ask Steve for some clarification on what we can do here. Whether or not we can do a variance
That would
as
be
we
renewed annually.
discussed, well, that involves an annual renewal of a lease permit that's tied to the variance.
Well, you guys, the board's probably done that, I'm going to guess, 10 times in
Yeah.
the last several years.
Yep.
Most
How's it
recently, a few months ago, with Craig Copeland over on Schaefer Street, and he was to reserve parking at the HDL Center. We've got quite a few rental properties that have this provision of a lease every year. It's really not that hard, to be honest with you. I'm not saying that we see it every year, but we see it at least every 2 years. And what's nice about the records down at our office is that they're all public. You can come in and look at them. And if a tenant wondered where their parking was, they could come to the office even if they hadn't been offered the parking spot or the lease hadn't been provided. It's part of the, that the action tonight of the board is contained in the official rental permit file.
Okay.
So, and we always encourage people to come in and look at those files. Look at all the properties, especially in the uptown area, that have recently been granted variances for in same ownership but distance. So what we have is underutilized, especially second floor areas, really, to be honest with you, in the uptown area. The upstairs above O'Hooley's was falling apart, and but the new owner could deed restrict parking, but it was just at too great a distance. Same thing at Taco Bell. Where else? We had a couple other places.
Had one there above the old Varsity Theater, didn't we?
Yeah. So
Yeah,
I
but
think
this would be right next door, parking that would be available for a tenant, which would be convenient and probably usable and would be used.
yeah, the first and easiest and cleanest, but maybe not the most effective, is to grant a variance for stack parking for 5 cars. That would be the easiest and least likely for anything to go wrong as far as paperwork would go, follow-up. The second would be to either allow stack parking for 3 vehicles for the business use, or just acknowledge, as Mr. Malcolm said, that even though it doesn't meet the strict requirements for size, you can pass 3 cars by each other. Technically, it just doesn't meet the size requirement.
If we granted stacked parking, wouldn't that go with the deed, though?
Sure.
Yeah.
And that's what we want to avoid.
Well, the board can attach safeguards and conditions. So for example, if you didn't want it to go with this particular property forever, you could say, so long as the Presbyterian Church maintains offices at the premises. Or, if you didn't, then it would continue with the property. Any business that might happen to go in on the first floor would have a parking variance forever.
We don't want to do that.
Okay.
So, and then I can see too, even though it's in an R3 zone and it doesn't have the same privilege of using the parking garage for business purposes as the B2D district, there are many properties a lot further away from the parking garage that enjoy that benefit for their business use. This property just happens to be on the wrong side of that line of parking privilege. So,
But
in
they
reality,
also have a lot that's even closer and more convenient, more likely to be used, that could be made available for their tenants. So that seems like, to me anyway, to make a lot more sense than requiring their tenants to park all the way over the parking garage.
to be real honest with you, in my mind too, if I was a tenant here and the office was closed, and nobody was around, I'd pull my car in behind the building. Even if that lot was real close, I'd just pull back in behind the building.
You mean,
But,
I hope I didn't oversleep and get trapped there the next morning.
yeah,
yeah.
if it was Sunday morning, yeah, you probably would be trapped in.
they'll
So,
be up
but
on
what we're,
Sunday morning anyway.
we're just
Okay.
actually trying to match up parking spaces to uses and people. And it's all, to be real honest with you, it's hard then after the fact to say, well, this car is supposed to be here. And I'm going to check it today to make sure somebody in this office who's working here is parked right there. And that the tenant upstairs is parked right over there.
We want them to have, I want them to have
Mm-hmm.
5 spaces.
5 accessible parking places.
That's what I
Right. So-
think is fair.
So you could, in that case, the compromise would be just to acknowledge that you can move 3 cars for the business use in the driveway and in behind, and that there'll be two parking spots reserved by lease, provided copies of which will be provided to the code office yearly.
Okay,
And then
well,
at least, in
Quite
theory,
frankly-
all those spaces are reserved.
Well, I don't see why they don't put the tenants on the property and one employee and then the other 2 employees on the leased spots.
Well, that would work
Seems
too. You could have the 2 parking spots would
could
be
stick-
accessible for the
Right.
tenants, and the 3
Right.
leased
Yeah.
next
Yeah.
door.
that
Or you
makes-
could even just have 2 leased next door and allow that somebody who was employed by the church to also be on the property. I don't see why the tenants have to be next door, but okay, whatever.
Right.
Since they're paying for the rent, but anyway, all right, thank you very much. That gives us everything we need, I think. Is there anyone else? No. Is there anything else you want to say in rebuttal or in further elaboration? Because this is your opportunity.
I don't believe we have anything
Okay.
worthy to add. Thank you.
All right, in that case, then the discussion from the floor is closed, and we're ready. We're ready to, are we ready to have a motion to, or
Yes,
do we need
but-
further discussion first?
I just want to ask a question. Are we still talking about section 230801A and D? Since we
Inadequate
may not
progress-
be
provision
talking.
for ingress and egress to park, no.
So what do we
want the, but we are, to permit lease parking, it is to permit lease parking.
Reserved the business indication, in the accessibility section, which I believe
Is that still section A?
Don't they just need 5 spaces? Do we need to differentiate between whether it's office parking or
No, I don't think. we do.
apartment parking? Just-
Well, they can decide
No,
that.
but that we need to, we need to recognize that there are 3 spaces that are accessible now that can be used even though they are.
3 non-conforming
even though they're
spaces
non-conforming,
on site.
uh-huh. And then they need to
And
provide.
2 reserved by lease.
Right, that's it. And that is a variance from section 230801A.
Okay. I move that we grant a variance to the Presbyterian Church at 9 North College Street from section 230801A to permit them to use 2 existing non-conforming parking spaces,
3.
3.
and
Oh.
the third on-site parking space to be reconfigured so that it allows access to the original 2, and to permit lease parking on the adjacent lot for 2 spaces.
Such leased
Yes,
space
lease-
to be
lease-
notified
Renewable
annually.
yearly.
Yes,
Annual
okay,
renewal.
yes.
Renewed
And
annually,
with
yeah.
the provision that they provide proof of the lease as required by the code office, as frequently as the code office may suggest.
I second.
All right. Then, that being the case, what is the practical difficulty or undue hardship that makes it necessary to provide this remedy? Practical difficulty or undue hardship caused by exceptional circumstances pertaining to a specific piece of property. Well,
We've changed the answer to the remedy. We just,
why do we need to do this, though? Why do we need to permit them to do what they're
There's
already,
There's wasted residential space if it doesn't get used.
well,
the hardship was that they changed it from a business to a rental and a business, and they needed to comply with updated parking, and that was not possible. Because you
well,
can't have stacked parking in that zone as rentals.
Well, perhaps the hardship is what Mr. Pearson alluded to when he said that some businesses have the right to use the parking garage when they're closed, and for some bizarre reason that I don't quite understand, the church is not allowed to use the parking garage for its business use.
I agree.
So they don't have the same privilege that some other downtown businesses do to use the parking garage. Is that right?
well, that's their preservation of equal property rights, isn't
Well,
it?
no,
Yeah.
that's the hardship.
That's
They
also a
can't use
hardship,
that.
that they can't use it, but then they do, and the reason that they need to be able to do that is the hardship of having this peculiar property that they've sold off part of, so that they don't have any parking lot any longer.
Well,
They
but
don't really have a
everybody who
space.
comes for parking has the problem is they don't have enough room for
Yeah,
parking.
well,
So
there's
that's
that.
not a particular hardship. It seems that
Okay.
the other thing is more of a
So
hardship.
the other ones, okay, I'll grant that one. What make, and this would be your exceptional circumstance also then,
Perhaps could be, sure.
as well as property rights. Literal interpretation of the code would deprive the appellant of rights commonly enjoyed by others who can put their parking in the garage.
Okay, I could go for that.
Okay, minimum variance. We're only really needing 2 more parking places.
Right, and the fact that
And it's-
they're not any distance away at all is in their favor. It's right next door.
Right.
And they already have those 5 spaces reserved, so they can use 2 of them.
And absence of detriment, it seems that they're already parking 3 cars there, so that's not a detriment to continue to do it. But then the additional parking being provided right next door seems like it would ameliorate any kind of detriment that might exist. It will keep the cars off the street. I can't, is there a detriment?
That's not an option to have them on the street.
No, well.
You keep them from
And
being
there's a
required.
detriment, they're required, okay.
required to have
Okay,
parking.
doing what you're supposed to do is not, doesn't give you, you don't get any penny points, okay. How is there, well, would granting the variance cause any detriment to adjacent properties?
I don't think so.
No.
I don't think so.
No, okay.
No one will notice.
And general nature, is the variance something that we really should be considering having the law changed instead?
No.
Okay. Are we ready to vote then? Why don't we start at this end? How do you
I
vote?
vote yes.
Yes.
Yes?
Yes.
And I also vote yes. Just annual paper exchange with the code enforcement office. Okay, great.
Well,
And
it's the same here.
Mr. Sligo, did you, yeah, you probably did. 5 all, okay.
338-9.
All right, our next case
338,
is 0619V, like Victor, the 919 East State Street Kroger Company is the appellant.
You did, you showed me
And
one, but
Steve
apparently
is
it was a misprint
otherwise
since it
occupied
got
at
2 of them that agree here.
We're needing a variance for an
Which is
improvement.
.04. Isn't that ridiculous that even have to come up here?
And could you tell us the specifics of the refusal for the Kroger Company?
So I can tear it down.
My name's Steve Pearson. Another one of the duties assigned by the administration to myself is flood damage prevention administrator. And I was thinking too in the opening statement that the chair always reads the types of variances you grant.
Left that
We don't
part
have
out.
anything in there about
No, we don't, and then we
the
should.
board being the appeal body for Title 25.
So we ought to put something in there.
So I'll revise that and make sure that that goes in there, because the standards and the requirements for variance are a little bit different for Title 25 than they are for 23. As a matter of fact, this case, or this particular property, some improvements to the Kroger store 5 years ago was heard by the board, and what I did was I attached the minutes of that meeting to the packet of information that you received.
Yes. I remember
And
that.
just for a little history, the original permitting by the city of Athens for the original structure was based on a monument or a marker out in the old railroad bed, which was found to be different in elevation than what everyone thought. So Kroger's originally built at what they thought was a protection level based on a baseline elevation provided by the city. And all that information is contained in those minutes of that meeting from 5 years ago. What I'd like to point out too, and it really didn't come out too much in that meeting, the National Flood Insurance Program, for a city to be a participating community, requires that you adopt at least the minimum standards required by FEMA. In the case of the city of Athens, we have higher standards as concerns flood protection of structures. And we have what's called a 1-foot freeboard requirement, which is all buildings have to be protected to at least 1 foot above the base flood elevation, where the national minimum standard is at the base flood elevation. What we're talking about here is a difference of about 8 inches. So the structure itself now, on which a variance was granted, exceeds the federal minimums by 4 inches, but is 8 inches below our local requirements. There was information presented at that hearing too about engineering considerations, why you couldn't flood-proof the building or try to keep the water out. I think as I read through the minutes of that meeting too, I had spoken with Nancy Olson, who's a FEMA administrator with I think it's District 5 in Chicago. And at that time, she said anything that had been mispermitted required a variance. So that's why 5 years ago Kroger had a variance for their substantial improvement to the building. Right now, the idea is to add a little over 20,000 square feet of additional floor space to Kroger's. It's indicated, the size of it's indicated on the drawing that you have. In speaking with Cindy Crecilius, who's the director of Ohio Department of Natural Resources Floodplain Management Division, she's informed me that any variance granted for a structure, that variance does not continue to additions to that building. So, saying all that, that's why we're here. The variance granted 5 years ago applies to the existing building, but does not carry over to any addition.
And as 5 years ago, it still is the case that granting a variance to this property would not in any way put at risk the city's
Standing in-
standing with, as far as flood insurance
Right.
goes.
I was just looking today at the state floodplain management website because I was asked the question if the city of Athens was actually a compliant community. This was in relationship to the possibility of the city participating in a program called the Community Rating System, where FEMA comes in, they look at your record keeping, your permitting, your documentation, your regulations, and they determine if you score high enough on a point scale to reduce everyone's flood insurance. For example, you only have to reach a 500-point threshold to qualify for the first flood insurance discount. The fact that the city has a 1-foot freeboard constitutes 300 points. So I believe right now, if we go through all the process to participate in the community rating system, more than likely we can top that 500 mark fairly easily. Several years ago, I don't know if you remember or not, I was in quite a controversy with floodplain management people in the Ohio University because ODNR said City of Athens should be permitting for Ohio University. And after all that was said and done, OU is self-reporting now to the state. The city has no responsibility toward permitting at Ohio University. So that's why I have a pretty close working relationship with the people in Columbus. As a matter of fact, they were just down here yesterday giving a presentation on community rating system, higher standards, hazard mitigation, and some things to help the city of Athens. So
And
I appreciated them coming
nothing
down.
with this project out there on East State Street would in any way interfere with what you've been being
No,
told
it
about
wouldn't. As a matter of fact, when they-
our eligibility for.
When they
these
come in,
interest
that's one of the
rates.
things they look at. When they come in and do their, what they call the community assistance visit, they want to look at a record of all the variances that have been granted, and they want to see if there's any, anything that doesn't seem reasonable at all. There are some communities who have, older communities that have many older buildings that are very much below the base flood elevation, and there's an exception for historic structures. Well, that's structures that are on the historic registry, but this particular town was just granting variances. We're saying they didn't need variance because they were old buildings. They called them historical. That community went on probation. That community also granting many variances for older structures that were damaged greater than 50% of their value. The cases where they granted variances, that was also a determination that put the community on probation for a few years. So
Not gonna do
I guess
that.
to answer your question, no, I don't think if we
We're-
exceed the federal minimum, but just happen to be 8 inches short of our higher standard, that that's going to be any kind of problem at
That's
all.
what we wanted to know. Okay, thank you.
As a matter of fact, the findings that are necessary to reach that first 500-point plateau, I think we meet that already. It's just a matter of finding the time to jump in the process of the federal bureaucracy. So
Okay.
we're about to jump in, though, I think.
Does anybody have any other questions for Steve right now?
No.
Thank you.
You're welcome.
All right, we're ready to hear your presentation.
My name is Jerry Turner, and I'm with the consulting engineering firm of C.F. Bird and R.J. Bull out of Columbus, Ohio. I'm here as the applicant for the Kroger Company. With me tonight is also Matt Hobart with the Kroger Company, who is with the Facilities Engineering Department. I think Mr. Pearson pretty much has said what needs to be said. We're here requesting a variance based upon the fact that we presently had a variance for the existing conditions. Unfortunately, the original building was built at an elevation below that needed. That's here said and done. We can't do too much about that. The bottom line is, if we don't get this variance, we're going to have difference in floor elevations, which could affect accessibility to handicapped people, as well as logistics in the building itself with the aisles, etc. Not saying it couldn't be done, but it would just be a hardship on the Kroger Company to have different floor elevations.
How many inches are we talking about?
3.5, 4,
That's what I thought.
above the 100-year
Yep.
floodplain elevation.
So you're
Yeah.
already 11.
I
Something
might
above.
add, and I don't know if Athens is involved with this, but a lot of communities in the state of Ohio are revisiting their floodplain elevations, and new mapping is occurring throughout the state. I've been involved in other areas where the floodplain has dropped since the initial incorporation of the FEMA maps done some years ago. I don't know if Athens is involved with that, but the floodplain could even change. I will say engineeringly that I do not think, it is my opinion, that this addition will not raise the 100-year floodplain. An actual detailed hydraulic study would have to be done to determine that. Of quite expensive. You'd have to take in the whole tributary area, upstream and downstream of our development, survey that area, and determine whether or not this development would change the floodplain by 1/10 of an inch. I do not believe that would occur, being an engineer and having been in the business.
3 or 4 inches just isn't very significant.
No, no. I have not been here, and I don't know, has it flooded to that elevation in Athens?
Yes.
Okay. In 1959?
No, I think several years ago, the
Oh, really?
parking lot was full of water and it splashed across East State Street and ran all over somebody else, so.
Yeah.
To get in our building?
No.
No.
Okay.
Walmart and parking lot was really underwater, though, not the building.
It was acting as a detention basin.
Yeah.
Good of them, yeah.
They have detention basins at Walmart, that's what flooded.
Okay.
Okay.
Are there any questions? For myself or
Do
Mr.
you have
Hobart?
any others for us? Like about whether it floods or not?
No.
Never mind.
No, I do not.
Okay. Any questions? No. All right. Steve has some general information?
Really, I think this is just information for the community more than anything. The federal government allocated $1 billion for map modernization of the whole United States several years ago. Ohio is in the process now of revisiting every flood map in the state. That map modernization project, City of Athens was scheduled to be on the list for this year. I just received from ODN, our floodplain management, a letter that says other communities are in more dire need of mapping sooner. We haven't flooded nearly to the extent of a lot of other communities have, so we've been set back a year until '07. So City of Athens is going to be, the maps are going to be modernized. New studies could be done to an extent that that FEMA does them, which is really may not have as much scrutiny as it might be done locally. For example, the Ohio University a couple years ago commissioned the Army Corps of Engineers to study the 6.5 or 6.6 river miles of the Hocking River through the City of Athens. The Corps returned a report which they gave to the Ohio University and presented to the Athens City Planning Commission that actually indicated, as Mr. Turner had said, that the flood hazard area had actually become less in area rather than greater. The Ohio University study was based on 35 years worth of additional data since the maps were originally generated 1979, 1980. Did not include, however, calculations for fill that had been placed in the flood hazard area throughout the city. So that, as we go through map modernization and possibly through community rating service, those things will come to play. It costs about $10,000 per river mile to do this kind of engineering work. So the city could just let FEMA do it at whatever extent they wanted to. They could use the Corps of Engineers study if they wanted to as better available data than what the current study is based on. Or if we wanted to study the river from end to end, 6.6 river miles would cost $66,000. There's a great interest at City Council right now about doing this kind of thing. They know the map modernization, the higher standards, those kinds of things, and an elevated interest in the local residents and citizenry about development in the flood hazard area. You know, this is a good point in time, a good discussion time, I think. But I think, too, what it indicates is, as Mr. Turner said, you know, we're not talking about very much, and we're probably talking about a building when the maps are modernized that will comply.
Well, that would be good. Okay, thank you very much.
Yeah, and the flood was a year ago, January. It was the highest flood event since the river was rechanneled in the late 70s, early 80s. So it was the worst event we've seen since 1980, but it was nowhere near a 100-year event.
Okay.
No.
All right. Do do you have anything further that you would like to say? Is there anyone here who is speaking in objection to, Mr. Sligo? You're not objecting, or are you objecting? You're speaking in general comments?
Make a couple of remarks. Maybe it'll help you realize how important this is. Joseph Richard Sligo, here's what I found interesting. I didn't know these minutes were in here, and I found out the minutes were from such and such a date. I tried to find it January 9, 2001, and there's one sentence in there that caught my eye. So on page 2, Ms. Frederick asked if this would put the community flood insurance program at risk. The zoning inspector, Mr. Pearson,
Said no.
said that he asked the Ohio Division of Water about this and has not received an answer as yet. Did you ever get an answer?
Yes.
And
And the answer was?
The answer was no. It would not be something that would jeopardize or stand.
Because Kroger insures themselves, and they wouldn't have any effect with this change. Is that what the argument is?
That was Kroger's argument at the time.
Oh,
Yeah, there'd be no claim against the federal program or the federal insurance, since Kroger self-insured. So we're looking at taxpayer burden. No, there's no additional taxpayer burden.
see, and the question is, when they put this building in, are they jeopardizing the people that have flood insurance?
And the answer
And your answer
apparently
is no.
No.
Well, I did the following. I went out there and I walked in the hot sun with my coat on to look where this was going to be. And you might be interested that I paced myself by 4 feet. I got 21,200 square feet, and you have 20,800. So see how close I am?
That's very good.
Now, the other thing is, I got the impression the building is going to be as high as the existing building.
Absolutely.
And the way I found out how far you go is somebody told me that Payless was that other building, so I walked over there. I was not smart to have done this, but I didn't know it was that hot. I'm in favor of this, and the only thing I'm concerned about has been answered by Steve and by your questions from the chair. And that is, when you do something, and the federal government, or FEMA, or OSHA, comes around and says, well, you might have done that, but you weren't authorized to do that. I think we're authorized to do this. I think it makes sense. I'm in favor of it. And you're asking for a difference of 1 foot?
3 or 4 inches.
Well, but I subtracted 637.13 from 638.13.
Yeah, you get .04
But
feet.
He was doing 60, he was doing-
wait a minute. My arithmetic must be wrong. 638.13 subtract
.13
637.13.
subtract,
It's 1.
no.
How come, then what am I doing wrong?
The figures I've got here are both are 638. One of them's .13, the other is .9.
He's looking at this
Oh,
one.
Well,
No,
I'm
mine
looking
is
at this.
637.
oh, well, you know,
And that's what was
that's
advertised.
what's, yeah, that's, it says something different on our,
Steve, wasn't that what
Sure
it was?
does.
See, this is
yeah.
Two
what-
different
what's on-
places,
What's on our
actually.
refusal is 637.13 as
In
opposed to
any event, the
638.13.
engineer assured us it was between 3 and 4 inches, and
Yeah.
But I don't
think
see any
that-
problem even, I just don't want to be wrong in the arithmetic.
discrepancy in the elevations is the
See the
fact
difference?
there are two
That's a
different
mean.
datums being used. There's a 29 datum and an 88 datum. Unfortunately, on my application, I used 88 datum, and the elevations, flood elevations are 29 datum. There's a 5700ths difference in those datums. This all gets real confusing math-wise. Trust me, it works. And it shouldn't be a problem.
That's why in the application, after talking with Mr. Turner, I lined out what they had originally put on their application because I wanted to try to make it clearer, not less clear. That's why I provided you with an actual FEMA 8113 form for when the building was finished with the renovations 5 years ago. The surveyor started at this right out here at Court in Washington, surveyed all the way out to Kroger, surveyed all the way back and verified the information. Took almost 2 days to do it. So that's why I thought that certificate and that number would be the more accurate comparison.
Okay.
Trying to get apples to apples instead of apples to oranges.
Okay. All right.
Thank you.
Thank you very much.
The board agrees that I did make a mistake in arithmetic.
Okay.
It was a mid course.
I'm in favor of it.
Okay. All right, is there it's now your place, if you would choose to do so, to make another statement, or do you have?
Any questions for me as a
Any questions? Any
No.
questions? I don't think so. And even though we're closing the discussion from the floor at this point, if we get confused and need to talk to you, we'll be talking to you. Thank you. All right, then the discussion from the floor is now closed, and we're ready to either discuss further here or take a motion and discuss it as we look at the findings, which way.
Let's take a motion.
Anybody want to make a motion, or
I move that we grant a variance to the property located at 919 East State Street, case number 06-19V, Zone M, the Kroger Company being the appellant. Appellant is requesting a variance from section 25.03.02B to permit substantial improvement to an existing commercial structure with a lowest floor elevation of 638.13 feet MSL, where 638.9 feet MSL is the required minimum.
second?
I'll second.
All right. Now, do we need to do exactly the usual findings, or seems to me that we do considerations from, as we did last time? I'm trying to find the consideration. There's 3 considerations, right? Yeah. Good and sufficient cause, exceptional hardship, or increase in flood heights, right?
And then attached sheet 2 about considerations. Will dangerous material be swept into other land or injured others, damage to life or property? There's a whole list of considerations, which most have been addressed in the discussion.
Well, anybody?
Support all of the considerations?
I'm looking for them right now, where the considerations are. I know we have them. Here we go. Considerations, here they are. All technical evaluations, relevant factors and standards specified in other sections. Danger that materials may be swept onto other lands, to the injury of others, danger to life and property due to flooding or erosion damage, susceptibility to of the proposed facility and its contents to flood damage and the effect of such damage on the individual owner, importance of the services provided by the proposed facility to the community, availability of alternative locations for the proposed use which are not subject to flooding or erosion damage, necessity to the facility of a waterfront location where not applicable, compatibility of the proposed use with existing and anticipated development, relationship of the proposed use to the comprehensive plan and floodplain management program for that area.
But are we not really just?
Basically, we're, we found, since this is an application for, to extend a variance, basically, that we already approved before and found all of those things to be,
Well, and the things are good and sufficient cause. Is there good and sufficient cause for us to give them a
Well,
variance?
the variance is required for them to be able to extend their, to make a...
Extend their building.
Yeah. I would think that the cause would seem good and sufficient to them.
Well, we know what their cause
We know
is.
what
Do
their
we
cause-
have cause to agree?
Well, that's of course a question.
I mean, is there good and sufficient reason to adhere to their cause?
I
I
would
would say that
rather
there
say
is.
that there is,
I
and
think
I would
so.
rather say that if,
I think there is. I'm just saying, are we considering the things that are on the piece of paper? Is there good
Yeah,
and
and I'm
sufficient
not-
cause? Yeah, probably.
Yes.
Yes,
Okay,
there
what
is.
about,
There was
would there be
sufficient 5
some
years
terrible,
ago.
would there be some terrible hardship if we didn't grant it?
to the
I'm looking at these
it's
things.
hardship if we did not grant it, or
With the Kroger company. They are
hardship
the
to
ones who are
the
asking.
community or to
To the Kroger company.
applicant.
They are the ones who are
Well, I should think
asking.
so.
There would be a hardship if they had to have a floor with 2 different levels and
Yeah,
they tried the
okay.
expansion without
Yeah,
variance.
I think they
essentially.
stated that it would be doable, but it would be extremely difficult and it would cause problems for their customers, possibly making some of the areas inaccessible to handicap. So I'd say,
These safety issues.
yeah.
But then is it going to increase the flood heights?
Well, it's been stated that if there is an increase, it would be so minimal as to make absolutely no difference.
Oh, there we
So-
go.
Anybody else? Any comments?
That says
All
it
right.
all.
Well then, are we ready to take a vote? Let's start with Betty.
I vote yes.
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 I also vote yes. We didn't even ask you what you're putting there. What's all going there?
We'll be putting, we'll be expanding the perishable for some employees in the store, but most of the additional space will be to general merchandise. We're building some stores in Columbus that they're called marketplace stores. They have for some furniture, some home office type supplies, bedding, home decor type items.
I see ads in Columbus Dispatch regarding
Yeah.
those.
And although the expansion of this store won't be large enough to allow that whole repertoire of product, it'll give us the ability to put some of that in here, which will hopefully enhance the shopping for the
Are you going to lose a lot of parking spaces?
parking spaces, but we still need the requirements.
Well, that was another question that I had. With this change, it's my understanding that along with the variance, when they get a change permit, do they not only, they also have to meet some new guidelines for landscaping, or is that only if we say so in the variance?
The landscape ordinance has specific regulations for retrofitting, including dollar improvement value thresholds
Yeah.
and square footage
Okay, that just
improvement area
automatically
thresholds.
happens, no matter, yeah.
Those things are under the review and the jurisdiction of the Tree Commission. The Kroger site landscaping plan and parking plan has already been presented to the Tree Commission. The engineer presented information where, even though they were losing quite a few parking spaces, they had to add a few onto the back of the building to meet the 277 parking spaces that were required.
Okay, so they're meeting all
Therefore, because the landscape ordinance says that essentially, if you have to make a ultimate choice between going below the minimum parking requirement and trees, cars win. You can't go below the number of cars that are required or the number of parking spaces.
Oh, you're kidding.
No. So, what the Tree Commission did then, and I faxed a copy of that letter to Mr. Turner. I actually have the original that I still got to send you. I meant to bring it tonight to give it to you. But when the Tree Commission reviewed the plan, they sent a letter back to Kroger/Bird and Bowl and said, you have existing landscape areas and plantings, some are in distress, some are dead, some could be a little better type. Also, you have city right-of-way in front of Kroger's, and the Ohio University, who's the prime leaseholder on the property, has a strip of grass area between the pavement where the trucks make deliveries in the rear and the bike path. So the Tree Commission has made recommendation that those existing areas be improved, updated, replanted, the right-of-way in front of the store be incorporated into tree plantings, and also the trees be planted behind the building.
Those areas behind the buildings can get pretty nasty after a while. Those plastic sacks and everything else blow down in there, and then they just lay there.
Yeah, it's about the lowest point in the area because all the other buildings around there meet the regulations, so they're all just a little bit higher, and that's the lowest spot, and it seems to catch all the bags from all the businesses. We're down there, code officers are down there quite often asking them to clean it up. It just seems to be a place that catches it. So just so you know, there's not been it's not that Kroger is trying to get around the regulations. They wanted to meet the minimum parking requirements, and Tree Commission's made some recommendations, which I understand the Kroger company is more than willing to consider and adhere by.
Okay.
So there's going to be some new plantings in existing planting areas. possibly new planting in the front and new planting in the rear. So even though they didn't have to do anything, they're going to follow the recommendations of the tree commission.
Oh, we're very glad to hear that. Thank you.
So there's the answer to that
Thank you
one.
very much. All right, we only have a couple of other things that we have to do this evening before we finish. One of them is to the disposition of the minutes from last month's meeting. Has everyone had a chance to read them? Have they found any corrections or
Looks all right to me.
additions or anything? Okay. Shall we, can I have a motion to approve the minutes?
I move we approve the minutes.
All right. Everybody in favor?
Aye.
Okay. I seconded it, I guess, but, all right. So the minutes are approved as written. The other thing is that we have something here from Altel, and I understand that you've been hearing wonderful positive
Oh,
remarks about the
absolutely.
Altel Tower and the new flag.
That flag is just
And
outstanding.
the-
People come to visit and they say, wow.
Wow, yes. I say wow, but when are we going to say wow about the trees?
At both recent Board of Zoning Appeals meetings and Tree Commission meetings, the issue of Altel's cell phone tower on East State Street adjacent to Route 33 has been brought up. One was the fact that the flag seemed very small compared to what Mr. Pitcher, the engineer, had presented the night he was granted the conditional use permit. And the Tree Commission also mentioned to me that the plantings weren't correct. I wrote that letter to Mr. Pitcher. He has not responded to me in writing, but he has contacted me by telephone. First thing he promised me was he'd have a larger flag up before the 4th of July, and he put that up, I think, on Saturday before the 4th of July, and I think it looks a lot better.
It sure does. That's
And
nice.
I mentioned to him, too, that the Tree Commission had required 14 blue spruce at least 6 feet in height at time of planting. He contacted the landscape contractor that they were working with. Excuse me. The contractor admittedly planted only 11 trees, and he said he couldn't find any 6-footers, so he planted 2-footers. I told Mr. Pitcher that wasn't going to work because it might jeopardize their conditional use permit.
You can find
The
bigger
plans
ones
they
than that down
presented-
at Walmart.
The plans they presented incorporated a recommendation of the Tree Commission because the board put it off for a month to get a recommendation from the Tree Commission about what the landscaping should look like. Tree Commission came back with 14 blue spruce at least 6 feet in height at planting. They planted 11 at 2 feet. Mr. Pitcher said he was going to get back to the contractor, and the contractor was going to come back to town and plant the trees that he was contracted to plant. So the flag part was easy. The trees are going to be a little harder, but the right trees will be planted soon.
We love our flag, and we're waiting for the trees. The
Suppose I can get a
flag
good-
is gorgeous.
Suppose I can get a good deal on those little ones.
Yeah, well, I hope the little ones don't just get,
Zoning
you know.
board should get first dibs.
right.
And just
We
so you
don't
know,
just
too,
trash those little ones. They're great little trees. It's just it'll be 20 years before they're big enough.
Oh, yes.
that flag is as large a flag as they can put up there, too. It's 20 feet by 30 feet. Any additional size of a flag would create such wind resistance that it might jeopardize, the
I think it's-
structure of the
it's
tower.
very,
Perfect.
very
The
appropriate.
proportions are absolutely right.
Absolutely.
Yeah, it's
Tremendous.
gorgeous. We love it.
There was one I got accomplished relatively easily. Some others aren't quite
That's
as easy.
nice. Well, I think we're done. We're adjourned.
I do have one
Oh,
other thing
we have
I'd
one
like to
other-
mention.
oh, beg your pardon.
We had announced at the last meeting that we were looking for an alternate
Uh-huh.
for the Board of Zoning Appeals. We'd mentioned that the mayor would take application for that, need to speak to him, provide essentially a resume. The mayor has also announced it at press conferences, weekly press conferences, and as of today's date, no one has responded.
Oh, come on.
So we haven't had one response. We do have one person who's expressed interest, but not turned in a resume yet. So I'll be talking to him again soon. There's just seems to be no...
Okay. I thought we
I
had
think we
a-
got the message out pretty good. People watch these meetings that seem interested. The mayor's announced it at a press conference.
I thought the mayor already had somebody who was really just...
Well, there is
ready-
one person.
Ready to start. There is one person,
Ma-
but we were
ma-
looking for one more.
Maybe it
Okay.
just doesn't pay enough.
Well, what needs to be considered
Oh,
too
I
is,
don't know. Maybe it's excessive. They're embarrassed.
if we can get that one person, we're kind of still in the bind because Mr. Shaft, as he mentioned a meeting or two ago, is committed to teach on Tuesdays. And he's kind of torn between, asking to be excused for several months or from resigning from the board. So,
Well, being excused for several months has a precedent.
Yes, it has.
I
Yeah.
think, having been there myself, I would be very comfortable, I don't know about the rest of the members, but I'd be more than comfortable with the concept of.
This is as
of
long
just-
as we don't become dysfunctional.
Right, right.
Continually.
Yeah.
I think
Well,
that.
if
what-
we get a second, if we could just get a second alternate, then we will have not got, we shouldn't have a problem.
So that invitation is still open from the administration. Anybody who would like to apply to be
Okay.
an alternate member of the Board of Zoning Appeals should submit a resume to Mayor Abel.
Everybody on the board, why don't you please look
Yeah,
around,
okay.
tell everybody. Okay, all right. Now, is there anything else, Steve?
No, there's nothing else that I have.
All right, then, we're adjourned.